Welcome, and thank you for joining us for today's Paid Family Leave webinar for employees. I'm Sarah McDonald from the Board Stakeholder Engagement Unit, and joining me is Courtney Valle from our Office of General Counsel. Today, we will provide an overview of New York State's Paid Family Leave benefit, including updates for 2026 and resources to help you if you plan on taking paid family leave. We will be using the chat feature to receive your questions today. You may enter your questions throughout the presentation in the chat box located on the right side of your screen, but we will wait until the end of the presentation to answer them. Courtney will answer as many questions as she can, but if we have any questions that we don't get to today, or if you think of something after the session ends, we'll be providing you with resources at the end of the presentation. If you have a specific topic you'd like to discuss more in depth with the board, please share that topic along with contact information in the chat box so the appropriate board staff can follow up with you. The chat settings are set so that only panelists can see questions or comments that come in, so you don't have to worry about others seeing your personal information. Before we get started today, we ask you to please keep in mind that the board is unable to provide legal advice, which includes guidance about what you should do in specific situations. If you have a specific question or concerns about a request for paid family leave, you should contact your disability and paid family leave insurance carrier, as they are the entity that makes the decision to pay or deny benefits. In today's session, we'll provide an overview of the New York State paid family leave and how it works, including uses, wage and time off benefits, employee contributions, eligibility, and how you request paid family leave. And we'll also review 2026 benefit and contribution information and information related to FMLA and highlight the many resources that are available to you. So let's get started with a little background. Why do we need paid family leave? For too long, employees have struggled to maintain their jobs when they need to care for a loved one during a specific time of need, whether that's welcoming a new baby, caring for a family member with a serious health condition, or dealing with family pressures when a loved one is deployed abroad on active military service. Employees in these income when they need to take time off to help with their family and fear their job may be gone when the family situation is over. In response to these needs, New York took action. In April 2016, New York Paid Family Leave, the nation's strongest and most comprehensive paid family leave policy, was signed into law. Paid family leave is employee-funded insurance that helps employees be there for their family when they're most needed. Because of paid family leave, workers across New York no longer have to choose between caring for their loved ones and their jobs, as we now have employee-paid insurance to help in these critical times. Paid family leave provides job-protected paid time off so you can bond with a newly born, adopted, or foster child, care for a family member with a serious health condition, or assist loved ones when a family member is deployed abroad on active military service. In addition to paid time off, New York's paid family leave also has strong employee protections. You are guaranteed to return to the same or a comparable job after taking paid family leave. A comparable job is defined as a position with a comparable employment benefits, pay, and other terms and conditions of employment. You are guaranteed continuation of health insurance while out on paid family leave on the same terms as if you had continued to work. If you contribute to the cost of your health insurance, you must continue paying your portion of the premium while on leave. You are also guaranteed protection from discrimination and retaliation. Requesting or taking paid family leave cannot be held against you. So let's take a closer look at uses of paid family leave. We'll start with bonding with a child. Paid family leave provides both parents time to bond with a new child within the first 12 months of the birth, adoption, or foster placement of the child. Parents who work for different employers can take paid family leave at the same time to bond with the same child. Parents who work for the same employer can take it at the same time unless their employer prohibits it. In that case, they can take leave separately over the first 12 months following the child's birth, adoption, or foster placement. It is important to note the expectant parents cannot take paid family leave for their own pregnancy. They can take it after the baby is born because paid family leave is used to care for someone else. A parent may be able to take paid family leave before the actual adoption or placement of a child if absence from work is required to finalize the adoption, or placement. Paid family leave is also available for employees to care for a spouse, domestic partner, child or stepchild, sibling, parent or step-parent, parent-in-law, grandparent or grandchild who has a serious health condition. A few other important notes for family care. Domestic partner is defined broadly under paid family leave law. It includes people who are not related by blood in a manner that would bar marriage in New York State and are dependent on one another for support. For example, an employee may be able to prove that they are in a domestic partnership by showing that they own property together or have children in common. A legal relationship is not necessary. It doesn't matter if these family members live outside of New York State or even outside of the country. Employees can take paid family leave to care for their family members as long as they are within close and continuing proximity. In other words, present at the same location as the family member they're caring for during most of the paid family leave period. This may include necessary physical care, emotional support, visitation, assistance in treatment, transportation, arranging for a change in care, assistance with essential daily living matters, and personal attendance services. In order to take this type of leave, your family member must have a serious health condition. Serious health condition is defined as illness, injury, or condition that requires either inpatient care or a hospital, hospice, or residential health facility, or continuing treatment or supervision by a healthcare provider. Here are some examples of other conditions that may qualify as a serious health condition. Maybe you need one or more full days to care for your mom when she undergoes chemotherapy, or your spouse or domestic partner had surgery and needs help recuperating at home, or your child is undergoing treatment for addiction and cannot attend school for a period of time. These are situations that may qualify for paid family leave and may be certified by a healthcare provider if they believe the condition constitutes as well as a serious health condition. The insurance carrier will make the final determination as to whether such conditions qualify for paid family leave. Since February 2019, paid family leave also explicitly includes support for organ donors. Former Governor Cuomo signed legislation to expand the paid family leave law's definition of serious health condition to explicitly include preparation for and recovery from surgery related to organ or tissue donation, ensuring those who donate can be cared for by eligible family members under New York State paid family leave. Non-serious medical conditions such as the common cold or flu, routine dental work, or cosmetic treatments are generally not included. However, if medical complications arise and your family member then meets the guidelines for serious health condition, it may be eligible. The third type of leave is for assisting during a military deployment. Paid family leave benefits are available when a family member is deployed abroad on active military service or who has been notified of an impending call or order of active service abroad and assistance is needed. Reasons for paid family leave for active service of deployment are the same as the military provisions of the Federal Family Medical Leave Act, or FMLA. They cover the employee's spouse, domestic partner, child, or parent. There are several instances where paid family leave will help, shown here on the screen. Now let's look at the program benefits and contributions for 2026. Eligible employees are able to take up to 12 weeks of paid family leave at 67% of their average weekly wage, capped at 67% of the New York State average weekly wage. An employee's average weekly wage is based on their last 8 weeks of taking paid family leave. For 2026, the New York State average weekly wage is $1,833.63. That means the maximum weekly benefit for 2026 is $1,228.53. This is $51.21 more than the maximum weekly benefit from 2025. The total maximum benefit of $14,742.36 if the employee takes all 12 weeks is over $600 more than 2025. It is important to note that employees can take this paid time off all at once or intermittently, but it must always be in full day increments. To estimate your wage benefit, use the 2026 calendar on the Paid Family Leave's website. Paid family leave is fully funded through employee contributions. The contribution rate is reviewed annually and is subject to change by the New York State Department of Financial Services. In 2026, the payroll contribution is 0.432% of an employee's gross wages each pay period. The maximum annual contribution is $411.91. Employees earning less than the current New York State average weekly wage of $1,833.63 will contribute less than the annual cap of $411.91, consistent with their actual wages. To estimate deductions, you can use the 2026 payroll deduction calculator on the Paid Family Leave website. So to summarize the benefits and contributions for 2026, eligible employees are able to take up to 12 weeks of paid family leave at 67% of their average weekly wage, capped at 67% of the New York State average weekly wage. An employee's average weekly wage is based on their last 8 weeks of pay prior to taking paid family leave. For 2026, the New York State average weekly wage is $1,833.63. That means the maximum weekly benefit for 2026 is $1,228.53. This is $51.21 more than the maximum weekly benefit from 2025. The total maximum benefit of $14,742.33 if the employee takes all 12 weeks is over $600 more than 2025. It is important to note that employees can take this paid time off all at once or intermittently, but it must always be taken in full day increments. Now that we've covered the types of leave, the benefits, and the cost, let's review who's eligible to take paid family leave. Most employees who work for private employers in New York State are covered under paid family leave. If you work for a public employer, your employer may opt into the program. If your public employer is represented by a union, you may be covered if paid family leave is collectively bargained. For covered employees, eligibility for taking paid family leave depends on meeting specific requirements for have worked for their employer. Full-time employees, including domestic workers, who regularly work 20 or more hours per week are eligible for paid family leave after 26 consecutive weeks of employment with the same employer. Part-time employees who work a regular schedule of less than 20 hours per week are eligible after working 175 days, which do not need to be consecutive. Citizenship or immigration status is not a factor in employees' eligibility. Paid family leave coverage is not optional for eligible employees. You can waive coverage if you regularly work 20 or more hours per week but won't be in employment for 26 consecutive weeks, or if you regularly work fewer than 20 hours per week and won't work 175 days in a 52-week period. Seasonal workers are a good example of this, as they may work full-time but only for 3 months out of the year. If you meet the criteria for waiving coverage, your employer must provide you with a waiver form, which is also available on the Paid Family Leave website. If you waive coverage, you will not make contributions and will not be eligible for paid family leave benefits. Employers should keep a copy of your waiver on file. If your schedule changes, such as you no longer qualify for a waiver, your waiver will automatically be revoked within 8 weeks of the schedule change. You can also voluntarily revoke a waiver at any time. If your waiver is revoked, your employer will begin taking paid family leave contributions and collect any retroactive amounts due. Now we'll cover how to request paid family leave, when you need it, as well as how disputes and issues will be handled. If you're an eligible employee, the maximum benefit is available to you once every 52 weeks. When you're ready to request leave, there are 3 basic steps. One is to notify your employer at least 30 days before the start of your leave, if foreseeable, or as soon as possible. Step 2 is to complete the request forms. Step 3 is to send all required forms to the insurance carrier. The carrier must pay or deny your request within 18 calendar days of receiving the completed request. or the first day of leave, whichever is later. You must submit your completed request package to your employer's insurance carrier within 30 days after the start of your leave to avoid losing benefits. You can get paid family leave request forms from your employer, employer's insurance carrier, or directly from the paidfamilyleave.ny.gov/forms webpage. If for some reason your paid family leave request is denied, or you have other claim-related dispute, such as the amount of benefits or timeliness of a carrier's decision, you may request to have the denial reviewed by a neutral arbitrator. Your insurance carrier or employer, if self-insured, will notify you of the reason for denial and provide you with information about requesting arbitration. Arbitration for paid family leave is handled by NAM, the National Arbitration and Mediation. More information on arbitration is available at the website on your screen, which is nyspfla.namadr.com. As mentioned earlier, your employer may not discriminate against you for requesting or taking paid family leave, and you are guaranteed job protection with the same or comparable job upon returning from paid family leave. If your employer does not return you to the same or comparable job, terminates you, or reduces your pay or benefits, or disciplines you in any way as a result of you requesting or taking paid family leave, you can file a discrimination claim with the Workers' Compensation Board. An administrative law judge may order an employer to reinstate an employee, pay any lost wages, pay attorney's fees, and pay up to $500 in penalties. The process and forms are available at the paidfamilyleave.ny.gov website, or you can call the Paid Family Leave helpline for assistance at 844-337-6303. We are frequently asked about the similarities and differences between paid family leave and FMLA. There are several similarities between New York's Paid Family Leave Act and the Federal Family and Medical Leave Act. Both provide leave for bonding with a child, caring for a family member with a serious health condition, and assisting when a family member is deployed abroad on active military service. You're also guaranteed that you'll return to the same or comparable position, and that your health insurance will continue on the same terms as if you had continued to work. If you contribute to the cost of your health insurance, you must continue to pay your portion of the premium cost while on leave. But as you see here on the chart on your screen, there are several key differences. PFL is paid, FMLA is not paid. Almost all private employers will carry PFL insurance, and FMLA does not include insurance, and it has a 50 employee threshold for eligibility. The length of time you must work is different. In PFL, if you regularly work 20 or more hours a week, you must be in employment for 26 consecutive weeks for that employer. And if you regularly work fewer than 20 hours per week, you must work 175 days for the same employer, which do not need to be consecutive. And for FMLA, you must have worked for a full year and 1,250 hours in the last 52 weeks to qualify. The biggest distinction may be that under New York's paid family leave, you are taking time to care for someone else, not for your own health condition. FMLA allows you to take leave for your own health condition. Also, PFL is only taken in full day increments, and FMLA may be taken hourly. Also, under PFL, you do not need to use other paid time off first. As you think about how paid family leave may be able to help you and your family, there are resources to assist you. Complete details on paid family leave are available at paidfamilyleave.ny.gov, along with other resources including paid family leave request forms and fact sheets, weekly deduction and benefit calculators, and updates for 2026. You can contact the Paid Family Leave helpline at 844-76303 for assistance. And if you are not already subscribed for email updates on the Paid Family Leave, you can subscribe by clicking Get Paid Family Leave Updates on the bottom of the paidfamilyleave.ny.gov homepage. New York State's paid family leave is administered by the Workers' Compensation Board. And if you're not already following the board on social media, we encourage you to do so. We are on X, Facebook, Instagram, YouTube, and LinkedIn. So link up with us. You can also subscribe to get board updates, the same ones our external stakeholders do, by hitting Get WCB notifications on the bottom of our website. So we hope that you found this presentation helpful, and thank you for the opportunity to discuss New York's landmark paid family leave with you. Before we begin the Q&A with Courtney, as I mentioned earlier, please keep in mind that the board is unable to provide legal advice, which includes guidance about what you should do in specific situations. So if you have a specific question or concerns about a request for paid family leave, you should contact your disability and paid family leave insurance carrier, as they are the entity that makes the decision to pay or deny benefits. And with that, I will give Courtney a moment to review the questions and hand it over to her.
Thanks, Sarah. I do see a few questions about if this is being recorded, if people will be able to get the PowerPoint and things like that. So if you wanted to take that one, I look at these ones that came in.
Sure thing. Yes, this is being recorded. It will be available on our website, and we will also send an email out to everyone that is subscribed notifications and those that are attending this webinar. So we will get that information to you as soon as it's available.
Okay, great. Thanks, Sarah. So I'm just going to start going through the questions here. So the first one we got in here is an employee who's a freelance theatrical technician who works with the same company on a contract-to-contract basis. This employee has worked 26 weeks of the last year there, but not all were consecutive. Is that employee eligible, and can they collect when they aren't actively on contract? So the first thing here is that eligibility is calculated separately per covered employer for paid family leave. And generally speaking, if an employee is employed with a covered employer and then they leave that employment and are later rehired, something like that, they would need to regain eligibility for PFL. I can't provide legal advice, so I'm not going to be able to make an eligibility determination specifically. But the second part of the question, can an employee collect when they aren't actively on contract? So a day of paid family leave is defined in the regulations as any full day that the employee was prevented from performing work for the covered employer because the employee took paid family leave. So if it's a day that they are not normally working, they can't take PFL. And the other thing to keep in mind is to be eligible for paid family leave, you do have to be in the employment of a covered employer. Okay, next question here is, my employer has a policy that says employees can take 18 weeks of maternity leave, but the first 6 weeks have to be used with disability. And then they're saying that I have to use PFL for weeks 7 through 18 of those 18 weeks. But I thought that I could take it at any time take PFL anytime within the first year, and they can't deny PFL. But can they tell me that that I have to use PFL weeks 7 through 18 following the birth of my child? So there's kind of two things here. Generally speaking, an eligible employee can choose whether or when to take paid family leave, and bonding leave for PFL is available for an eligible employee to take and complete at any time during those first 12 months following the child's birth or placement for adoption or foster care. However, if the employer has its own policy, so they're offering some kind of more generous benefits, or they offer a different benefit in addition to paid family leave, they can't abridge your right to take paid family leave. But how paid family leave and an employer's leave policy interact is going to depend on the terms of that policy. So if the policy is you get this benefit, this more generous benefit, or whatever it is, if you're taking these things concurrently, that may be acceptable. They just can't abridge your right to take paid family leave. But how PFL and an employer policy interact is going to depend on the terms of that policy. But generally speaking, for paid family leave, if you wanted to take it at some point later, it is available during the first 12 months following the child's birth. Okay, next question here is, if I don't need health insurance while I'm on leave, can I opt out just for the 12 weeks? So this is not specifically addressed in the PFL login regulations, but the PFL law and the law requires the employer to maintain health insurance on the same terms as if the employee had continued to work. So that's the employer's obligation. They are required to maintain the health insurance on the same terms as if the employee had continued to work. Okay, next question here is it acceptable for an employee to face disciplinary action if a PFL day taken if a PFL day is taken without providing notice to the employer? So, for example, same day, but I don't call into work. Is it considered no call, no show, or is it protected if the PFL is approved? So, you are generally required to provide at least 30 days notice of foreseeable leave to your employer, or as much notice as possible if the leave is not foreseeable. And generally, that does mean following your employer's leave policies. So if the policy is, an hour before the shift or whatever it is to call out, generally it's going to be interpreted that you can provide that notice. So it's as much notice as foreseeable as possible if the leave is not foreseeable. I can't provide legal advice, so I can't tell you whether or not if an employer marks that as a no call, no show, if that constitutes discrimination or retaliation. Under the law and regulations, the employer is prohibited from discriminating or retaliating against employee because they take or request paid family leave. But if it was something that would have happened, whether or not the employee was on paid family leave, that may be acceptable. But if you believe that your employer has discriminated or retaliated against you because you took a requested paid family leave, you are free to file a discrimination claim, and that would be heard before a workers' compensation law judge, and they would hear all the evidence and make a determination. Great. Next question here is, after exhausting 12 weeks of New York paid family leave, when is an employee next eligible to take PFL and for how long? So this does differ a little bit. Like if you're familiar with FMLA at all, some employers do FMLA on a calendar year basis. So January 1st, you get your 12 weeks. That's not how paid family leave works. It is based on a rolling calendar year. So an employee can only take a maximum of 12 weeks of paid family leave in any 52-week period. And what that means is that, like, if you're going to take paid family leave on a day that you're going to be taking paid family leave, the carrier is going to look back 52 weeks and see how much leave you've taken. If that's 12 weeks, you're not eligible for any, but it's on a rolling calendar period. So it's not like on day whatever you're going to get your refresh of 12 weeks. It's always on a rolling calendar basis. So it's that 12 weeks in any 52-week period. Okay, next question here is, does an employee on paid family leave receive payment from their employer and the employer's insurance, or only the employer's PFL insurance? So generally speaking, it's going to just be a payment that you get from your employer's paid family leave insurance carrier. Paid family leave is an insurance product, and that's how it works, is that you apply, you give your employer notice, they fill out their portion of the PFL benefit, you send it to your employer's carrier, and then the employer's carrier pays you benefits. Now, an employer could pay the employee full wages and then request reimbursement from the carrier. They could agree, the employee and the employer could agree to top up the benefit so that they're getting benefits from the insurance carrier, but then also the employer is paying them a little bit more. The employer and employee could agree to charge like a third of a day or something like that so that you're getting your full wages during a period of paid family leave. But generally speaking, paid family leave, like the benefit, is just from the insurance carrier as an insurance product, and it's the insurance carrier who pays it out. Okay, next question here is, does an employee need to exhaust their sick vacation time before they can use paid family leave? And the answer is no. Under the PFL law, an employer is prohibited from forcing an employee to use accruals during a period of paid family leave, so it is a separate benefit. Okay, next question here is, if you're taking paid family leave intermittently, how do you determine the weekly benefit? If I get a bonus before the first month of paid family leave, wait 2 months and take another month, will the bonus be added into the weekly wage? So there's a couple things here. Intermittent paid family leave is going to be a portion of your average weekly wage. So average weekly wage is calculated using the last 8 weeks that you worked and received wages before the period of paid family leave. And then you divide it by 8, and that gives you your average weekly wage. Your daily intermittent amount is going to be a portion of that, depending on how many days a week you work, like that. It's going to be a daily rate that's equivalent essentially to the weekly rate. So that's the first thing. The second thing is if you are taking PFL intermittently, and this is all for one period of leave, the benefit rate that you get is the benefit rate that's in effect on the first day of that period of leave. So if you're taking PFL once a week for 10 weeks or something like that, and then you take two months off, but then you're going to have another few days, and it's all for the same qualifying event, no new documentation, things like that. That's all part of the same period of leave, and so it's going to be the same regardless of whether or not you got a bonus during that time for something that happened before the leave, anything like that. When days of leave are separated by more than 3 months, then they're considered separate under the law, and then you would need to file a new request for paid family leave for those days, even if it's like for the same type of thing. You would still, they're under the law, they would be considered separate claims, and then you'd have to file again, and at that point your new average weekly wage would be counted. Okay, so your question here about which insurance carrier, health insurance or disability insurance. So for paid family leave, the benefits are going to be paid by your employer's disability and paid family leave insurance carrier. If you're asking about like how health insurance is going to be continued, that's going to be just your regular health insurance. It just the PFL law just says you're entitled to keep your health insurance on the same terms as if you continue to work, and then you'd pay your portion of that health insurance premium. But that's separate and outside like that. The PFL law just says you're going to be keeping your health insurance. Nothing with that insurance carrier or anything like that is changing. But the PFL benefits are paid by the PFL insurance carrier. Okay, I see a question here. If an employee works over 20 weeks or less than 25 due to premature birth, do they qualify? I am not sure that I understand your question. So if you want to pop down in the chat, put a little bit of additional context, and hopefully we'll get to it as we kind of go down here. But I'm just not sure that I understand the question. So if that was your question, please feel free to put additional context in the chat, and we can kind of circle back to it. Okay, next question here is, I know that the employer has to protect the employee's position while they're out on paid family leave, but what about the employee? Do they owe anything to the employer if they decide not to return to work? So if they quit, resign, and then don't come back to work. So there is no requirement in the PFL law or regulations that an employee return to work following a period of leave in order to get benefits. So there's no requirement there. An employee could decide, I'm resigning effective after my PFL date ends, and that's fine. There's no requirement in the PFL law that you have to return to work. You are entitled to return to the same or comparable position, but it's not required. So you could resign after your period of paid family leave, and that's okay under the law. There's nothing prohibiting that. Okay, next question here is how are the amount for paid family leave adjusted? So I'm not sure if you're asking how the average weekly wage is calculated or how your benefit amount is calculated, but if that's what you're asking, it uses the last 8 weeks that the employee worked and received wages prior to the period of paid family leave, and then that's divided by 8. And that gives you your average weekly wage. And then the benefit amount is 67% of your average weekly wage, unless you make over the statewide average weekly wage, and then it's 67% of the statewide average weekly wage. Oh, okay, I see another question. I actually think this may be clarification of the previous question, but how often is the employee contribution adjusted? So the Department of Financial Services sets the deduction rate every year. So that decision is reached by September 1st each year, and they post it on their website. So it is adjusted annually. Okay, next question here is, can both parents request PFL to bond with a newborn if they work for the same employer? So generally speaking, yes, employees can choose whether or when to take paid family leave, and there's nothing in the PFL law saying that they can't take leave at the same time. However, if they work for the same employer, the employer does not have to allow two employees to take paid family leave at the same time for the same family member. So in this situation, if it's the two parents of the child, the employer, and they work for the same employer, the employer can require them to take leave separately. They can still take the leave if they're eligible, but the employer can say you can't take it at the same time. If you work for different employers, there's nothing in the law prohibiting it from being at the same time. But if you work for the same employer and you're trying to take leave for the same family member at the same time, your employer can say, no, you have to take it separately. But you would still be able to take the leave, just maybe not at the same time. Okay, I see a question here about benefits and dependents while you're on FMLA. FMLA is a federal leave, so the board does not have jurisdiction over the Family Medical Leave Act. That is a federal law. Okay, next question here is, how do we receive payments? So like I kind of outlined before, once you send your completed application to the carrier, they generally have 18 days from the first day of leave or receipt of the completed request, whichever is later, to pay or deny benefits. And so you will receive payment from the insurance carrier. So it'll be your employer's disability and PFL insurance carrier, so the same one that you sent your application to. Okay, I see a very involved question asking about an overview of employee-employer obligations, contribution structure, things like that. That's really kind of, we went over that a little bit in the presentation. If you want more information, you can go to the Paid Family Leave website, and then if you toggle over to employers, there's an employer responsibilities page on there, and that gives a very good overview of all of that stuff, but we don't have time to go into all of that detail. But so Sarah, I think you put it up on the screen. So if you go to that website and then you hover over employers, and then you'll see employer responsibilities and resources, and that's what you want to click on. Okay, next question here is, if my sister lives in another state, can I still apply? So assuming this is talking about you want to take leave to care for your sister and she lives out of state, yes, there's nothing in the PFL law or regulations requiring that the family member live in the state or even in the country. So something to keep in mind with this, though, is that you do have to be providing care and you have to be in close and continuing proximity to the family member for which you're caring, which means that you have to be present in the same location as the family member for the majority of the leave taken. So as long as you're actually going to your sister out of state, or if she's coming to you, whatever the case is, you do have to just be in close and to continuing proximity. But there's no requirement that your sister live in New York State or even the country or any other family member. Okay, next question here is it required for PFL and FMLA to be used concurrently, or can they be used one after the other? So if, generally speaking, available FMLA and paid family leave for the same qualifying event are required to be taken at the same time. So the employer can say you have to take these at the same time. There are, when I say available FMLA, I mean if you are eligible for both, and so for example, bonding is a very common example. You're eligible for FMLA and you're eligible for paid family leave and you want to take bonding leave, generally those are going to be required to be taken at the same time. If you are not yet eligible for FMLA, but you're eligible for paid family leave, that doesn't prohibit you from taking paid family leave. So you could still take paid family leave. It's just if you have both of those benefits available to you and it's for the same qualifying event, you're taking it for the same reason, then generally speaking, it is going to be taken at the same time. Okay, next question here is what is the process for applying for part-time side hustles? So if you have multiple jobs, eligibility, deduction amounts, benefit amounts, all of that is calculated separately per covered employer. So you would need to gain eligibility at each covered employer. And then if you gain eligibility, you would need to apply separately. If you're eligible at multiple employers and you have a qualifying event, you don't have to take paid family leave from all of them. But if you don't, you can't later go back. Like you couldn't take, say you have 2 jobs, you couldn't take bonding leave from job A and then 6 months later say, well, now I want to take it for part B. If you're going to take it from multiple employers, you have to take it all at the same time, but you're not required to. It's just that if you don't do that, then just know that you can't later go back and say, actually, I do want to do that now. And then the other thing to keep in mind is that you can't work. So if you're taking paid family leave from job A, you can't now pick up shifts for job B during the time that you'd be working because you're on paid family leave. And as we discussed before, the definition of paid family leave is a day of PFL that you were prevented from performing work for the covered employer because you used paid family leave. So you just can't work the same or substantially the similar hours at another job during for that employer or for any other employer during the period of paid family leave. Okay, next question here is how does it work if the employer is a New York-based employer company, but they have employees working in New York or others that are remote out of New York State? So to be eligible for New York State paid family leave, you have to be what's called localized in New York. So your service has to be localized in New York. And essentially that means you have to work in New York. So if you live in New York, but you work in New Jersey, and you always work in New Jersey, you go to the office 5 days a week in New Jersey, that's your job, you would not be eligible for New York State paid family leave because you're not localized in New York State. You know, essentially there is a test and I'll put the workers' compensation law just if you want to look in more detail. But it's in section 201 and there's what's called a localization test. And that has various factors that you would look at. And that is essentially determining, do you work most of the time in New York State or do you work most of the time out of state? And to be eligible for New York State paid family leave, you do have to be an employee in employment in New York State. Okay, next question here is, are bonuses included in average weekly wage calculation? So yes, bonuses count as wages generally under the paid family leave law. And on the PFL1, so on the PFL1 is kind of the general overview, the employee information page of the PFL application. There's instructions on how to do that. You would add them all up, divide by 52, then add that to the weekly amount. But I do also just want to make you aware that it is for that employer. So it's if you're taking paid family leave from that employer, it's wages for that employer, but bonuses and commissions are generally included in wages. And the PFL1 does have instructions for how you would add those to your average weekly wage. Great, next question here is, oh, sorry, I lost my spot a little bit. Let me just, okay, here we go. Sorry about that. When do PFL premiums begin for a new hire? So a couple things here. If they're a new hire, they're full-time, you hire them, they can begin on day 1. You're going to have to cover them on your PFL insurance policy. So deductions can start from date of hire. The only kind of caveat to that I do want to make you aware of is if an employee is eligible for a waiver. So like we talked about before, this is an employee, maybe a seasonal employee, someone who regularly works 20 or more hours per week, but won't be in employment for 26 consecutive weeks, or someone who regularly works less than 20 hours per week and won't work 175 days. If you have either of those two categories of employees, the employer must be offering them the waiver before they ever take deductions. And if they execute the waiver, you don't take deductions from them. You keep the waiver on file. They don't take paid family leave. If they don't, then you can start to take deductions. So generally speaking, it's on hire, but you just want to keep in mind about the waiver. Okay, I see a question here. So I do just want to say I am seeing a lot of questions about FMLA. If your question is about FMLA, I am not going to be able to answer it. Generally, we don't have jurisdiction over federal, and like I said, FMLA is a federal unpaid leave. If you're asking about PFL, I try to discern, but sometimes it's a little bit unclear. Like I've definitely seen some that are definitely about the federal law. So I just want to reiterate that the board doesn't have jurisdiction over that. But I know sometimes it's easy to get confused about if you're asking about PFL or FMLA. So the question I see here is, are you able to take an hour or two under FMLA? So if we're talking about paid family leave, the answer is no. Paid family leave is not available in hourly increments. It is only available in daily increments, so full day increments. FMLA is available hourly, but like I said, we don't have jurisdiction over that. So I'm not going to be able to kind of go into detail about that, but paid family leave is not available hourly. Okay, I see a question asking about 1099 limits. The board does not have jurisdiction over tax matters, so unfortunately I'm unable to assist with tax-related questions. Okay, next question here. If an employee has applied for PFL to care for a father-in-law, but then their spouse has a surgery coming up, can they use that period of PFL for both instances, or can it only be used for the originally applied for situation? So paid family leave, if you are applying to care for a father-in-law, you can only take paid family leave for that reason. So that's what you've provided documentation for. That's what the carrier has approved. That's what your application says. So if you have a different qualifying event, you would need to reapply with documentation for that qualifying event. And you can contact your carrier, your employer's disability and PFL carrier if you have specific questions. But the PFL application does require essentially a healthcare provider certification. And so you can't use a healthcare provider certification for someone else to care for a different family member. You would need documentation for that as well. And then just keep in mind, you are limited to 12 weeks of paid family leave total, no matter how many qualifying events you experience. So it's the 12 weeks in a 52-week period, no matter how many qualifying events an employee has. Okay, next question here is, can PFL be used if only 1 day per week is needed? And the answer is generally yes. Paid family leave is available intermittently, so in increments of 1 full day. So once a week, if you have the documentation and you've applied, yes, PFL is available intermittently. Okay, next question here is, can an employee take PFL first before they take disability? So for example, if they're giving birth to a child. So generally speaking, an employee can choose whether or when to take disability and PFL, how they divvy that up. However, generally speaking, if you take 12 weeks of paid family leave, you're likely not going to be eligible for disability after those 12 weeks have elapsed, because generally it's 6 weeks for a vaginal delivery and 8 weeks for cesarean. Like if there are complications, you may be eligible for longer, but generally speaking, most people are not. If they take 12 weeks of paid family leave immediately after giving birth, they're not then going to be eligible any longer for disability. So it's just something to keep in mind. Okay, I see some questions about how holidays are addressed or interact with PFL. The interaction of holidays and paid family leave is not explicitly addressed in the PFL law. Generally speaking, if you're on, an approved period of 12 weeks, that's what you're going to get. You're taking continuous leave, that's what you're going to get. If you're taking intermittent leave, again, if you're taking it daily, a day of PFL is a day that you're prevented from performing work for the covered employer because you used paid family leave. So generally speaking, if you just need 1 day of paid family leave and it's a day that you wouldn't normally work, you are likely not able to take PFL for that day. Okay, I see several questions here about what is and is not sufficient notice. So, like I said, I can't provide legal advice. So those kind of questions are really good questions to bring up to the disability and PFL insurance carrier because they're the ones who are actually processing and paying or denying the request for paid family leave. So questions over whether or not something was sufficient notice are extremely fact specific and really going to depend on the specifics of the situation. And so that's really something that you want to be addressing with the insurance carrier. Okay, next question here is if I'm not eligible for PFL, I worked part-time for my employer for less than a year. What other benefits am I entitled to if I'm pregnant and giving birth in the spring? So again, I can't provide legal advice, and this does kind of include coordinating benefits that may be available to you, but as a general rule, if you work for a covered employer, you're in employment of a covered employer, you're probably going to be eligible for disability benefits. There may be other areas of law that provide benefits that I'm not aware of. I know that there's the paid prenatal leave law. Again, we don't have jurisdiction over that, so I can't go into detail about that, and I can't make eligibility determinations anyway. But the other thing that I want to just make you aware of is that if you gain eligibility sometime after your child is born, paid family leave is available for an eligible employee to take and complete at any time within the first 12 months following the child's birth or adoption, birth or placement for adoption or foster care. So even if you're not eligible when the child is born, it's possible that if you work enough and you gain eligibility, you would be able to take paid family leave once you gain eligibility. It just has to be taken and completed within that first year following the child's birth. Great. Next question here is if an employee is entitled to both PFL and FMLA, why would they take FMLA if they can get paid for PFL? So the answer here is really that the law allows the employer to require an employee to take those leaves at the same time. And the reason for that is so that an employee is not out for 24 weeks in a row. So the law allows them to say you have to take these at the same time so that you're getting the 12 weeks. So you're not necessarily getting an additional benefit for the FMLA, but the employer is saying you're taking these at the same time. If they didn't, and they allow you to take it at the same time, it could be 24 weeks. If you take 12 weeks of paid family leave and then you take 12 weeks of FMLA, or vice versa. That the law allows the employer to say if you're eligible for both of these things, you have to take them at the same time. Okay, next question here is asking about taking benefits for yourself. Do you go through disability? So yes, paid family leave does not provide benefits for your own serious health condition. It's to care for someone else. So if you have a serious health condition, you have an off-the-job injury or illness that prevents you from performing work, you're likely eligible for New York State statutory disability benefits. But paid family leave is always for someone else, not for yourself. Okay, next question here is how soon after paid family leave starts do I get money? So generally speaking, the carrier has 18 days from the first day of leave or the receipt of the completed request, whichever is later, to pay or deny benefits. So generally speaking, it's going to be around 18 days, sometimes a little bit sooner, but the carrier has that 18 days to pay or deny benefits. And then, sorry, I just wanted to clarify also. And then afterward, you would receive biweekly. So you would still, and your benefits are retroactive. If it's approved and you're getting benefit payments, you're going to be paid back from the first day of leave. It's just that they have the 18 days to process it. Okay, next question here. Is giving kind of a hypothetical. If an employee is pregnant and taking New York State disability, and they have to take it 5 weeks prior to their due date because of complications, and then they take disability after. If they take the full 26 weeks of disability, can they now take PFL for 12 weeks? So the answer is no, in that there is a combined maximum of 26 weeks of statutory disability and paid family leave that an employee can use. So they are limited to 26 weeks in any 52-week period for disability and paid family leave. Okay, next question here is if an employee uses all 12 weeks of paid family leave but needs more time off, can they then use FMLA? So generally speaking, like we've discussed, they would not have FMLA available to them if it's something that also qualifies for paid family leave. Because if they're eligible for paid family leave and they're eligible for FMLA, generally those are going to be taken concurrently, meaning at the same time. So generally they would not be able to use FMLA because they will have exhausted it at the end of that 12 weeks. Okay, I see a question here. So no notice needs to be given to an employer if you plan to leave. So there may be, if you're talking about someone resigning and not returning to leave after a period of paid family leave, there's nothing in the PFL law or regulations requiring notice of resignation. There may be other areas of law that require some notice. I'm not aware of any, but there's nothing in the PFL law or regulations requiring that. Great, next question here. If an employee doesn't meet PFL eligibility until after they've given birth, so say 2 months after, can they take PFL at that point? The answer is yes. So if an employee isn't eligible for paid family leave right away, they continue working, they've gained eligibility now at some point, and it's still within that first year of the child's life or placement, they can take paid family leave. It's available for eligible employees to take and complete at any time within that first 12 months following the child's birth or placement. Okay, next question here. I see a few questions here about what if someone works per diem. So per diem, you're still going to be counting on depending on how much they work. So if an employee regularly works 20 or more hours per week, they're still going to become eligible for paid family leave after 26 consecutive weeks of employment with a covered employer. If they regularly work less than 20 hours per week, they're still going to be eligible after working 175 days in the employment of a covered employer. So that's really, there is no real difference for per diem employees versus a salaried employee. You're still going to be calculating based on whether they regularly work 20 or more hours per week or regularly work less than 20 hours per week, and then you use the applicable timeline for eligibility, assuming that they're in the employment of a covered employer. Okay, so I do see a clarification of that question we asked before, asking if the employee worked less than 25 weeks due to giving birth prematurely, do they qualify for PFL? So if the employee regularly works 20 or more hours per week, they only become eligible for PFL after 26 consecutive weeks of employment. If they regularly work less than 20 hours per week, they would become eligible for working 175 days in the employment of a covered employer. And then I did just also want to kind of make note that periods of statutory disability do not count toward eligibility for PFL. Okay, I'm still seeing a lot of tax questions, and I do just want to kind of reiterate what I said before, is that the board does not have jurisdiction over tax matters. I'm also seeing some very, very detailed hypothetical situations, or maybe they're not hypothetical, but I am seeing some very detailed information and then asking if the person is eligible. I cannot provide eligibility determination, so that would be legal advice, which is applying the facts of a situation, the law to the facts of a particular situation. So these are questions that you would really need to be sending to your employer's disability and PFL insurance carrier. In XYZ situation, do they qualify for paid family leave? That's really going to be a question for the carrier. Okay, next question here is what type of proof is required by paid family leave to qualify an event as a serious illness or other qualifying event? So there is a very long definition of serious health condition, and I will give you the citation. So I just put that in the chat. That is where you can find the definition of serious health condition. There is also on the PFL 4, which is the serious health condition portion of the PFL application, that requires a healthcare certification, and the healthcare provider has to certify a serious health condition and the need for leave. So there's a very long definition, and then, like I said, the healthcare provider also has to certify it. Okay, most of the remaining questions, because I know we're pretty much out of time here. Most of the remaining questions are extremely specific. But I do see some confusion still about disability and FMLA. So I'll answer that and then I'll turn it over to Sarah to kind of close us out. But obviously, feel free to call the helpline if you have additional questions. And then Sarah will kind of give you an overview as well for how you can get any remaining questions answered, because I know we don't have time to get to everything. But generally speaking, when we're talking about taking short-term disability and 12 weeks of paid family leave, if the employee is eligible for disability, they can take disability. If they're then eligible for paid family leave, they can take that. There is a combined statutory maximum of 26 weeks of statutory disability and paid family leave that any employee can take in any 52-week period. So they can't take 26 weeks of disability for, say, their own serious health condition and then later take 12 weeks of paid family leave. But and this is extremely common when someone gives birth, they could take the 6 to 8 weeks of disability followed by 12 weeks of paid family leave. If they're eligible for both, that's perfectly fine. So you just really, it's that 26-week combined maximum that you want to keep in mind. But I'll turn it back over to Sarah.
Great. Thank you, Courtney. And thank you everyone for joining us today. I just wanted to reiterate that the recording of this webinar will be available on our website. You can go to the wcd.ny.gov, scroll to the bottom of that page, and you'll see webinar recordings. If you click on that, it will bring you to our YouTube page, where you will see multiple options of different webinars that we have recordings of on there, including PFL ones. And as I mentioned earlier, we will be sending that out. So I know there was also a lot more questions about that and the Q&A part in the chat. So I just wanted to reiterate that. You can also sign up to receive paid family leave news, including information on future webinars, straight to your inbox. To sign up, visit the Paid Family Leave website, scroll down to the bottom of the homepage and select Get Paid Family Leave Updates. We also, as I mentioned, distribute information on our social media channels, so please follow the board on Facebook, X, Instagram, and YouTube. Once again, thank you, Courtney, and we thank you all for joining us, and enjoy the rest of your afternoon.